Hey there, I'm Louisiana estate planning attorney Paul Rabelais, and in this video we're going to talk about that decision people make as to whether they should build their estate plan by using a will-based estate plan or whether they build it by using what I call a trust-based estate plan. All right, so there's lots written, lots said out there on the internet and in books and other writings about whether someone should have a will or a trust. So here, I'm going to explain what's common and what's different about the two ways to arrange your estate plan. One through a will-based estate plan, one through a revocable living trust estate plan. First, the will-based estate plan. That is really the traditional way. It's probably a way you're familiar with. People write a will to provide where things go when they pass away. They leave everything in their name. And then when they pass away, their assets are frozen and their survivors, maybe their spouse, maybe their children, perhaps the executor and the heirs that are listed in the will have to retain a lawyer or lawyers because it's just the way it is. There's a court-supervised process of transferring the assets that one owns when they die that are in their name. There's a court-supervised process involved to transfer those assets from the name of the person who passed away to the names of the heirs, using the will and court pleadings, and judges get involved, and judges have to sign court orders for assets to be transferred to others, and third parties and banks all rely on those court orders. So that's the traditional way. Person writes a will. In addition to their will, they're also going to typically create other estate planning legal documents, your financial power of attorney, which covers who can transact for you during your lifetime. It's often used when you're alive, but you're unable to transact for yourself. You can't pay your bills, you can't sign on your accounts. The person that you designate in your power of attorney will be able to do that for you during your lifetime. Your will controls what happens when you pass away. Also, people typically create a healthcare power of attorney in Louisiana who can talk to your doctors, access medical records, make medical decisions for you. There's another healthcare document people often create in Louisiana called a living will or a living will declaration. That's your statement regarding life support machines in the event that you're in that vegetative state with no chance of recovery. You can relieve loved ones and family members from being forced to make that difficult decision. So that's the kind of traditional, typical, kind of basic estate plan for people in Louisiana. Will, financial and healthcare powers of attorney, and living will. And when you have that kind of plan, you leave everything in your name. You leave your accounts in your name, your house in your name. But when you die, those assets are frozen and your survivors must hire lawyers to go through what's called the succession process to get lawyers and judges involved so that ultimately judges will sign court orders ordering financial institutions to release funds to certain people. All right, and even if you have a will-based plan, it's likely that not everything you own will be frozen when you pass away, requiring court orders to be released. You may have a individual retirement account, you may have a 401k plan, you may own life insurance, you may own an annuity. All those things are the types of accounts where you can have designated beneficiaries. And when you pass away, that beneficiary or beneficiaries that you designated upon producing a death certificate and filling out some paperwork will be able to get access without going through the traditional probate process. So that probate or succession process typically governs things like all of your real estate, including your home, your bank accounts, brokerage accounts that are not part of a retirement account. So enough on that. That's the will-based plan. Very, very traditional, and quite frankly, it works. Now, the other option that people have when they're creating an estate plan is to create what's called a revocable living trust-based estate plan. The primary reason people do that is so that they can prevent their survivors from going through that court and attorney involved succession procedure when you pass away. The idea behind the revocable living trust, let's say John Doe is doing his estate plan. Of course, in Louisiana, Doe is spelled D-E-A-U-X. And so John Doe creates his John Doe Revocable Living Trust. He names himself as the trustee. The trust says he can do whatever he wants to with the assets while he's alive, but the trust says when he passes away, he names someone to be the successor trustee of his trust, and he names beneficiaries of his trust to receive the trust assets when John passes away. And so that trust really replaces the will. And as part of the revocable living trust-based estate plan, John also retitles those assets that would have been required to go through the succession when he died. Had those assets been in his name, John retitles those into his trust. So the real estate, his home, for example, and other real estate may be retitled from John Doe to John Doe as trustee of the John Doe Trust. His business interests, his LLCs, his brokerage account, all retitled from John Doe to John Doe as trustee of the John Doe Trust. The idea there is things in a trust don't get frozen when you pass away. They don't have to go through the court and attorney involved succession process. So if John had a brokerage account, for example, and John passes away and that brokerage account is titled in the trust, then we look to the trust instrument to see who's the successor trustee of the trust now that John has passed away. Yes, that brokerage firm may need a death certificate to prove that John died, but really other than that, that successor trustee is going to have immediate access to distribute that trust account to the trust beneficiaries that John designated in the trust instrument. And all that gets done without having to get lawyers and judges involved. And in many cases, that can save considerable time, expense, and hassle. So bottom line here is the will-based plan. That's traditional. It's well known. You write your will, you leave everything in your name. It's relatively simple to build that. And then when you die, though, there's generally more complexity involved because things get frozen. Family members have to hire lawyers. Lawyers have to prepare all the court pleadings. Heirs have to, of course, participate in all of those court proceedings. And as part of those court proceedings, if you follow all the procedural rules, which can be a little bit cumbersome, judges at the end of that proceeding will sign court orders ordering that the assets be transferred to the appropriate heirs that are named in the will. But there's expense and delay to that succession proceeding. Or do you do your revocable living trust? Little more effort while you're alive. You've got to retitle some things. But when you pass away, if it's set up properly and the things that need to be titled in the name of the trust are in the trust, we call that the trust is funded properly, then there will be no succession, or as they call it in states outside of Louisiana, no probate procedure, and that successor trustee can distribute the trust assets to the trust beneficiaries, often without any expense or delay. So there you go right there. You know, there you have it. A little bit of difference between will or trust. Some people kind of get, they kind of hesitate in their tracks and they don't know what to do. Maybe this explanation helps a little bit. Make sure you like the video, comment, subscribe. We need all that activity. We'll see you next time.